Morning to you. Thank you for staying with TV3. Welcome to another edition of Election 360. It is just 38 days to December 7, 2024. And today we'll start our show from the Supreme Court, where the case of the Speaker of Parliament, Alban Bagwin's declaration of 4 seats vacant in the House of Parliament has triggered a number of political conversations and legal conversations. At the court today, the Supreme Court today, the lawyers for the Speaker have been making a strong argument and asking for, amongst other things, asking for one particular thing, which is that one of the members of the 5-member panel should recuse himself. And you're talking about Justice Ernest Jewu, Justice of the Supreme Court. Why? It is because of his public political affiliation to the NPP, and the lawyers for Speaker Bagwin say that that is going to, force him to speak in a particular way, is likely to show his bias because of his public support for the NPP. So they are asking that he recuse himself. But beyond that, the Attorney General, who is also party to this case, is asking that 2 specific paragraphs in the motion filed by the lawyers of the Speaker be struck out. Now, when the court resumes, the court is on recess as we speak, but when the court does come back, they will be giving us the specifics of how they intend to rule. You're watching Election 360, and later in the show, I'm sure for you who've been following, you will know that the Electoral Commission has suspended the printing of ballot papers, and this is because of the death of Madam Ekua-Donkor of the Ghana Freedom Party. Now, they've asked the party to nominate a new candidate to replace Madam Ekua-Donkor on the ballot paper. We'll find out what all of that means in the show in the next few minutes. And later, we'll touch base with the various aspirants on the campaign trail to find out what exactly the campaign is looking like with just 38 days to December 7, 2024. This is Election 360. Stay with us. We'll delve into the details in a moment. Welcome back to the show. My name is Martin Esiedudate. Let's delve into it. Now, this show clearly is primarily to inform you and keep you in the loop of all political activities happening in the country. And if it has to do with politics and elections, this is the right platform to give you all the necessary updates. Today, we're starting from the Supreme Court. Why? It is because you'll recall that a few months ago, and we'll take you down memory lane when we go to the touch screen in a jiffy, but you'd recall that a few weeks ago, I should say, Speaker Alban Bagwin declared 4 seats vacant, and after that, the case was sent to the Supreme Court. Like you see, that was the day of the argument, where the NPP side of the House, the then majority, said that the Speaker had erred in his ruling. So they staged a walkout. On the back of that, they served the House of Parliament with a writ from the Supreme Court saying that the Speaker should not implement his order of the declaration of 4 seats vacant. In other words, they asked the Speaker to stay the execution of that declaration. And stay in execution is a legal parlance which simply says, do not implement what you have said or the decision you have taken. That threw the whole Parliament into a frenzy, where the NDC then says they are now the majority. The MPP refused to accept that and said they are rather maintaining the majority position in Parliament. There has been a back and forth on that. So beyond the politics of the conversation, it became a legal matter. Now, the Speaker asked his lawyers to also write back to the Supreme Court and ask the court to set aside that decision of asking the Speaker to stay the execution of his order. So today, the court asked that the case be heard. And it's actually being heard in public, or it's open to the public to follow. And here at TV3, we've been bringing you live coverage of how the conversation has gone so far in Parliament. The Supreme Court has resumed sitting on the application for a stay of execution by Speaker Bagben's declaration of some 4 seats vacant in the 8th Parliament. That's actually the first time that we've had this particular conundrum. The Apex Court a while ago took a break to determine an application for Justice Jew to recuse himself from the 5-member panel because of his public support or public declaration of support for the NPP, because he was a one-time parliamentary candidate on the ticket of the New Patriotic Party. Parliament has formally communicated to the Chief Justice rejecting a lawsuit seeking an interpretation of Article 97(1) of the 1992 Constitution. In a statement issued by the Deputy Clerk of Parliament, the Speaker, Alban Bagben, emphasized that the suit was improperly served by the 3 bailiffs on the 16th of September 2024. He argued that this action violated Article 117 of the Constitution, which prohibits the service of court processes on the Speaker, members of Parliament, or the Clerk of Parliament while they are on their way or attending to Parliament or returning from a parliamentary proceeding. So Speaker Bagben further highlighted that the action that was taken by the bailiffs contravened a circular previously released by the Judicial Secretary, which reinforces the enforcement of Article 117. So simply put, because of how Parliament works, you cannot just get up and serve them a court summons or a court writ. You need to go on a specific day. Most often, you can only serve Parliament on Mondays because the House hardly or does not sit on Mondays. So if you want to serve Parliament, you serve them on Monday when they are not sitting. But if Parliament is in session, you cannot serve the House because they are in session. You cannot serve a member of Parliament who is on his way to Parliament. You cannot serve a member of Parliament or the Speaker when he's out away from just doing parliamentary business. So those are the contraventions that the Speaker sought to draw the court's attention to, that the day of the service itself was against the statutes of when Parliament can be served when it has to do with court summons. So you can't just get up and serve Parliament. That's the argument primarily. Away from that, the case actually now was formally served on the House when Parliament was not in session. The Speaker acknowledged the service from the Supreme Court, which was sent to the court by the NPP leader in Parliament. I'm talking about Alexander Penyomake, MP for Futu. And the conversation has actually gone further, where now, in acknowledging the service from the Supreme Court, the Speaker has also asked his lawyers to write back to the Supreme Court to tell them that, I acknowledge your service, but I expect that you consider these other major issues, one of which is that the time you served us was wrong. Secondly, the issue was not supposed to have even come to the Supreme Court in the first place. Constitutionally, any major issue having to do with parliamentary conversations has to be heard at the High Court, not the Supreme Court. So the Supreme Court does not have jurisdiction in even hearing the case that was filed by Alexander Penyomake. So that is one of the issues they are looking at. And while the case has actually been heard, or the hearing has started on the case in the court, the lawyer for the Speaker, and in the person of Thaddeus Sorry, has asked for one of the panelists of the 5 judges who are sitting on the court, Justice Ernest Jew, to recuse himself. Like I indicated, he has at some point in time been a member of Parliament aspirant or a parliamentary candidate on the ticket of the New Patriotic Party. And that is where they say that it is open bias, or there's a likelihood of open bias because of his affiliation to the New Patriotic Party. Lawyers or those who become judges are supposed to be neutral so they can give straightforward judgment devoid of any political bias or inkling. that is where the conversation is now. The leadership or the judges have actually gone on recess to consider a number of the conversations that have been captured or that have been had so far in High Court. And so what we'll do now is to take you down memory lane, how we got here in the first place, and then later we'll speak to our correspondent in the court who have been following the proceedings to try and make sense of what has gone on so far and what the next expectation would be, where we know that the judges would be returning to the court in a short while, hopefully before midday, and we'll be giving some ruling regarding the orders that were asked, or, for instance, whether or not Justice Jewu would have to be asked to leave the panel. That will mean they need to bring someone else to replace him, because the judges of the court need to be beyond, it shouldn't be an even number. It's either 3, 5, 7, 9, and then on and on and on. It can't be 2 or 4 or 6. So that's where another conversation we can have, in a bigger basket of all the big issues that have come up so far. So maybe we have to now go to the board and walk you down memory lane and bring your mind specifically to the key issues under discussion now. Eric Mana Egbeta is my colleague who's joined me in studio, where we're going to be having that conversation now. Mana, thank you for joining us. So
pleasure
to start
always,
with,
Martin.
Take us back. How did we even get here in the first place? It was at a rally that all of this happened, isn't it?
Perhaps we take a step back from that rally and been listening to you based on the analysis and the proceedings as we've had it in court over the last, 1 hour plus, where the arguments have been made forcefully by lawyer Thaddeus Sorry. And so before the October 12, which is the date of this rally, which drew the attention of the entire nation to a possibility of a showdown or development in Parliament, we know that the EC's notice of poll and the development within the respective parties had been laid bare. Those were crystallized or were made factual by the Electoral Commission's notice of poll, which detailed these 4 seats, which I believe you've gone through already. Fee Central, Guna West, and the likes, Fomena, and then one more just escaping me briefly. And so the Electoral Commission's notice of poll sort of accentuated the fact that these members of Parliament were not returning on the ticket of the party that brought them into the 8th Parliament, which sets this ball into action. Haruna Idrisu, at a campaign ground in Tamale on October 12, mounted the podium and said, look, we're going for the majority status because 3 members from the caucus of the NPP, the former MP inclusive, which forms the majority in Parliament, they've lost their position by virtue of their decision to want to go independent or switch to the camp of the NPP. After that announcement, we know in anticipation of the return of the House, the then, I don't know if then majority leader is an appropriate word to use, but at the time he was, Martin. At the time he was. So Alexander Lapenyo-Markin, he preempted the sitting of Parliament, went to the Supreme Court aiming to arrest what was expected to be a motion by Haruna Idrisu. After that, Parliament, we know, resumed sitting. Haruna attempted. The majority leader then, Lapenyo-Markin, drew the attention of the House to the fact that this and this was the case. He had filed a case at the Supreme Court seeking interpretation of the specific provisions of the Constitution upon which the Speaker was going to use as a basis to declare these seats vacant. We know
and
that
also key among what he was seeking the court to do was to injunct the Speaker from even going ahead to declare the seats vacant, because he had sensed that if it does happen, the minority, then the NDC were going to be a majority.
Absolutely.
So he was asking for 2 things: the court to interpret what the Constitution says, and then also the Speaker to be stopped, if even he has the power to be stopped. All right, so we are told that the conversations in Parliament, I beg your pardon, now the Supreme Court is just about to start. So we are crossing over back to the Supreme Court, where 5 judges are hearing the case that we've just been discussing, whether the declaration of 4 seats vacant was constitutional or not. So let's go back and pick that feed. Right.
Is a former member of Parliament for the National Democratic Congress, a former General Secretary of the People's National Convention, it should be well understood that when Parliament approves a qualified citizen to be a Justice of the Superior Courts, pursuant to Article 1284, the representatives of this country have appreciated the ability of that qualified person to contribute to justice delivery in the country. Second, the subject matter of this suit before this court is a constitutional dispute and not a matter involving political parties. The objection is therefore misconceived. Move your application and dismissed.
We have before the court an application praying the court for an order vacating.
So sorry, can you do it in 10 minutes?
Very well, I'll try to. The order of the court dated the 18th of October 2024 and setting aside the processes of proceedings in the court leading to the order. We have set out the grounds on the face of the motion paper. There are 8 of them. Now deal with the first ground. The first ground is that the writs or the processes on the basis of which the court's jurisdiction was invoked for the order are void because they were filed in violation of the rules of the court. The rules of the court are within the cognizance of the court, so I will not elaborate them. But it's important to state right from the outset that they concede the fact that the processes were filed contrary to the rules of the court. But all they are saying in the affidavit of opposition is that the court is capable of carrying, not by reference to Rule 79 of the rules of the court, but Order 81 of the High Court rules. My Lord, we are saying that that irregularity is incurable, and this court has re-emphasized that in very recent cases in this court. My Lord, I will refer just to 2 cases. The case of Mahama Yarga, an Attorney General, writ number 1, J1/13/2022, dated 29th March 2022. There's also the case of Ken Kranchi versus Attorney General, writ number J1/16/2023, ruling of the court dated 14th November 2023. All these were writs which invoked the original jurisdiction of the court to interpret the Constitution. This court held that a violation of the rules nullified the proceedings. We also want to emphasize that by the decision of this court in the case of National Investment Bank number 1 versus Standard Offshore Trust Company number 1, reported in the 2017 Supreme Court of Ghana Law Report at page 707, the court held that where the provisions in the rules of court use the word shall, it is mandatory and should be enforced. We urge the court to follow these decisions. We should also add that where the irregularity complained about arises from originating proceedings, like in this particular matter, the court has also been consistent that such irregularities cannot be cured. So, several reasons why. In writs, recently the court has made the point, nullifying the writs. Secondly, the rules are mandatory, and this same court says that when they are mandatory, they will be enforced. And finally, where the proceedings are originating in nature, can be no waiver. There can be no waiver. That's the recent position of the court. But we're saying also that even if it were curable, which it is not, the court's jurisdiction, substantive jurisdiction, to entertain the matter as a whole was not properly invoked. It was not properly invoked because the court lacked jurisdiction to entertain the matter as a matter, the purpose of which is to determine whether or not the seat of a member of parliament is vacant. That matter belongs exclusively to the jurisdiction of the High Court. And this court has affirmed that consistently, not deviated in one, that if it has to do with the membership of a person in parliament, that belongs in the realm of the High Court, not this court. But I would want to emphasize the point that, admittedly, in every instance, they would say that the facts on the basis of which they are before this court arise. There will be a dispute between two people regarding whether or not the person properly is a member of parliament or not. And that has to be determined by reference to the constitutional provisions. It won't make it a dispute properly invoking the original jurisdiction of the court. What I'm saying is that wherever the question arises as to whether or not a person is properly a member of parliament, whether he ceases to be or his seat is vacant, there will be disputing positions, there will be differing positions, but the Constitution says it's the High Court that must determine that matter. And in this particular instance, the question is whether the parliamentarians who are the subject of the instant suit, their seats have become vacant. And the Constitution clarifies the position by telling the High Court the instances in which those seats will be deemed vacant. It is a cross-carpeting situation. So it's a matter of evidence for the High Court to go into and find out whether the facts establishing those circumstances in Article 97 have arisen or not. It's not a question of interpretation. But we are also saying that the court has no jurisdiction to stay execution of the ruling of the first defendant. And that one, 3 main points will deal with that. First of all, the substantive suit before the court never challenged the ruling of the Speaker. The suit before the court had nothing whatsoever to do with the ruling of the Speaker. Interlocutory reliefs made by any court of the land relates to the substantive dispute before the court. That dispute was never before the court. And so, once the dispute was not before the court didn't even have jurisdiction to make an interlocutory relief in respect of that ruling. Second, the High Court's ruling, the first defendant's ruling, is not a judicial decision which is properly the type of order or ruling which is the subject of the court's orders for stay of execution. At the very best,